Recording.
Hey, good evening, everyone. For the record, my name is Paul Haverty, Town Council with Blattman, Bobrowski, Mead, and Talaman. The purpose of this training session tonight, I would call it, is just to give an overview of how Chapter 40B works and how the process works. The PowerPoint presentation that I have for you tonight is adapted from a presentation that I've given multiple times through the CPTC, which is a planning organization that does 40B trainings. I've adapted a little bit so that there's some of the extraneous stuff was taken out. But I want to make it clear that this is simply to go over how the Chapter 40B process works. We cannot take any questions tonight with regard to any potential or pending applications, because we would run into open meeting law concerns and issues if we did that. So I just want to make sure that any questions that are asked, and I encourage throughout the process for people to ask me whatever questions they want, as long as they are general process questions and don't address specific issues with regard to any pending potential projects. Okay, so that's one I should have gotten rid of. So again, we're talking about the statutory minima regulatory requirements. So I'm sure many of you know Chapter 40B requires a municipality to have minimum amount of affordable housing. And there's actually 3 different statutory requirements. If you meet any one of the 3, you can claim the safe harbor and actually deny Chapter 40B applications. The first one is the one that's most well known. It's the 10% year-round housing unit requirement. The second one is the 1.5% land area requirement, which has become really a hot topic in Chapter 40B. There are a number of different municipalities that are trying to find a way to meet this requirement rather than the 10% requirement. So far, to the best of my recollection, there's only been one town that's ever successfully shown that they meet the 1.5% requirement, but it's becoming more and more prevalent. And the last one is the 0.3% total land area requirement. Not only have I never seen a town meet this, I've never seen a town even raise it as an issue. It's just completely overlooked and not used. So after the regulatory safe harbors, there are actually the statutory safe harbors, there are actually regulatory safe harbors as well. So the first one is housing production plan, which my understanding is the town does not have a housing production plan currently. It's a really good tool that can be used. What it is the town actually drafts a plan that addresses how it could meet its 10% affordable housing requirement. It requires a lot of specifics in terms of the housing need and the ways that the town could reach the 10%, including identifying locations specifically where affordable housing development would be appropriate. Once a town has that plan, if they approve either 0.5% or 1% of their total year-round housing units in one calendar year, they get either a 1 year if it's 0.5% or 2 year if it's 1% safe harbor, which means the applicant comes in, files for a 40B, the town can either say no, go away, or they can actually move forward and hear the application, knowing all the while that any condition that they impose is automatically going to be upheld if there's an appeal. Another good thing about the housing production plan, safe harbor or regulatory provision, is that planning can actually be used even if you're not at certification, is what it's called, for the 0.5 or the 1%. Particularly, it can be used during a project eligibility process. If the town can show that they've actually made significant progress towards developing affordable housing and that they have a plan that they're following that's getting them and moving them towards the 10%, Mass Housing has, on occasion, and not often, but occasionally, has actually denied project eligibility requests based upon planning issues. The best thing about getting a denial at the Mass Housing stage or the project eligibility stage is it's not appealable. So if they don't get their eligibility letter, they're done. The next safe harbor is a recent progress safe harbor, and that is if at the date of application to the board, the town has approved up to 2% of its total year-round housing units as affordable units. So you look back 12 months. In that 12 months, have you approved enough units to hit the 2%? If you have, you're eligible for the safe harbor and you can either deny or approve with conditions. There's also another safe harbor. It's a large project safe harbor, and that's based upon the size of the municipality. So if it's greater than 7,500 year-round housing units, that threshold is 300. If it's between 5,000 and 7,500, the threshold is 250 units. If it's between 2,500 and 5,000, the threshold is 200 units. And if it's less than 2,500 units, it's 6% of all housing units. So I took a look at the DHCD subsidized housing inventory today. Newbury is listed as having 2,699 year-round housing units, which means that it would be a 200-unit large project safe harbor. So what that means is if an applicant comes in and they have a project and it has 210 units, you could deny the project as not consistent with that safe harbor. So they're not going to come in with a project that's beyond that safe harbor if they know what they're doing at all. And the last safe harbor provision is the related application safe harbor, and that takes another 12-month look back to determine if there were any other applications for development on the particular site and whether or not those applications included affordable housing. And if they didn't include affordable housing, then they have to wait 1 year before they're allowed to file a comprehensive permit application. It's known as the cooling off period. Now, a very important thing to remember, particularly for the Board of Appeals members, with regard to safe harbor provisions, is that there is a procedure for which the board has to notify an applicant that it believes it has met one of the safe harbor provisions. Specifically, the board is required to provide the applicant with written notice within 15 days of the opening of the public hearing that it believes that it's met one of those safe harbor provisions. And it doesn't really get into that. So it's not something that seems like it would be an issue in this town in the near term, because I don't see any safe harbors that would be hit anytime soon. But the process is that you have to give them the notice within 15 days. They've got appeal right. It's an interlocutory appeal, which means they don't have to wait to the end of the process. If we put the process on hold, they file a letter to the Department of Housing and Community Development. The HCD takes a look at it, makes a determination as to whether or not the safe harbor was properly applied or whether it was not, and then there's appeal route to the Housing Appeals Committee. It's happening actually fairly frequently due to that 1.5% safe harbor issue. There's been a number of towns that have tried to raise that safe harbor, have issued letters to applicants. Applicants have taken their appeal. DHCD has overturned in every single instance. The town has taken appeals to the Housing Appeals Committee. Housing Appeals Committee has upheld, and there are at least 4 or 5 different appeals currently pending at the trial court levels on that issue. So we have critical 40B application submission requirements. So now we're getting into what has to be done after an applicant has gone through the project eligibility stage and is ready to file with the municipality, with the Board of Appeals. So in this slide, we're talking about what needs to be submitted as part of the comprehensive permit application. So that includes evidence that the applicant is either a public agency, a nonprofit, or a limited dividend organization. And generally that evidence is simply the project eligibility letter from the subsidizing agency. As part of their application requirements, the applicant is required to commit to being a limited dividend organization. They're also required to submit evidence of site control, which means a deed, a lease, an option, purchase and sale agreements. Site control is something that is frequently attempted to be raised as an issue during a Board of Appeals hearing. People trying to claim that there's some sort of cloud on a title, there's an easement problem. All the applicant has to show is that they have a colorable claim of title. If there is somebody that's trying to say that there's a title problem and that they have interest in the land rather than the applicant, that's generally going to be something that has to be deferred to the courts. If somebody wants to bring an action challenging the status of the site control of the applicant, it's not really for the board to determine. That's not what their role in the process is. The application also has to include a copy of the project eligibility letter from the subsidizing agency. Without that letter, there is no right to file for a comprehensive permit with the Board of Appeals.
So all What exactly is a limited dividend organization?
A limited dividend organization is generally what you're going to see as an applicant. Occasionally you'll get the nonprofits, and basically it's usually a single purpose entity. An LLC is created and the applicant agrees to limit the return on their project consistent with the requirements of Chapter 40. So any entity can be created, all they have to do is say, will be a limited dividend entity, and they qualify. The application has to include preliminary plans that show the location and outlines of proposed buildings, proposed locations, general dimensions and materials for streets, drives, parking areas, walks and paved areas, and proposed landscaping improvements and open areas within the site. Projects of 5 or more units have to have site development plans prepared by a registered architect or an engineer. It also has to be a report on existing site conditions, include a summary of conditions in the surrounding areas, show the locations and nature of existing buildings, existing street elevations, traffic patterns, character of open areas, if any, in the neighborhood. There has to be preliminary scaled architectural drawings, there has to be a tabulation of proposed buildings. When there's a subdivision involved, there has to be a preliminary subdivision plan. There needs to be a utilities plan showing proposed location and types of sewage, drainage, water facilities, including hydrants. And finally, the applicant has to submit a list of requested waivers. So I'm sure most people are aware under Chapter 40B, an applicant is allowed to request waivers of local rules and regulations. That means really a lot of different areas, but zoning bylaws, subdivision rules and regulations, local conservation commission bylaws, local board of health bylaws, things along those nature that are local and not statewide. But the town entities that actually have jurisdiction over state issues, such as the Conservation Commission under the Wetlands Protection Act or the Board of Health under Title V, retain that jurisdiction. So they will issue approvals under the Wetlands Protection Act or under Title V, and the Board of Health has no jurisdiction over those issues. So now we get to notice in conducting the required public hearing. This is some important information that can get you in a lot of trouble if you don't follow it. So under Chapter 40B, once a comprehensive permit application has been submitted, you have 7 days from the receipt of that application to distribute all the material to the different town boards. That's not really a significant deadline. That's
7 calendar days?
Yes, but that's really more of a suggestion in terms of when the town should inform the rest of the boards in town and the departments. You're not going to get into any trouble if you do it on the 8th day or the 10th day. No more than 14 days from the receipt of the 40B application, the initial public hearing must be advertised with proper legal notice and proper notice to abutters. That's very important because if you don't meet that requirement, you won't be able to meet the next requirement, which is within 30 days of the receipt of a complete comprehensive permit application, the public hearing has to be opened. If you don't open the public hearing within that 30 days, the applicant can go in directly to Housing Appeals Committee, make the argument that their application has been constructively approved, and you'll lose your ability to do anything, make any conditions, and they're just going to go home free. So you've got to make sure that that initial hearing is held within that 30-day period. As I discussed a little bit, I'm sorry, is there a question? Just feel free to shout out.
Is the town required to notify abutters?
Yes.
Or is it not the applicant?
Not the applicants.
By regular mail?
By certified mail is generally how it would be done.
Thank you.
You're welcome. I already went over the 15 days from the public hearing. That's the safe harbor provision. That's 15 days from ZB action, 30 days, that's all part of that. So the next deadline that needs to be understood is the 180-day deadline. So once the board opens its public hearing, it has 180 days from that date to close the public hearing. That often, it seems like a long time, often is not enough time to actually complete the process. You will find that applicants are generally willing to give additional time because usually you're not ready to close it because they haven't done a good job of getting you the information that you need. And if at the end of that 180-day period, there are legitimate issues that the board needs to review that it has not had the opportunity to review because of delays on the end of the applicants, then the board can deny the project for lack of information if the applicant isn't willing to continue to keep it open. However, if the applicant has been, submitting all of his information in a timely manner, has not requested multiple continuances, and is not extending the process unreasonably, and you get to that end of the 180 days and the board still wants time, then you've got a problem, because if the applicant denies it, you're probably just going to have to close the hearing and make do with the information you have.
Paul, can you use the word board in this particular instance when you get clarity on what board you're referring to?
Every time I'm referring, it's to the Board of Appeals.
Okay.
The Board of Appeals is the entity that has all of the jurisdiction. The Board of Appeals actually serves as every single local board as part of a comprehensive permit application. If there is a permit that is issued locally by the Board of Selectmen, the Board of Appeals is the Board of Selectmen. If there is a permit that's issued under a local bylaw by the Conservation Commission, the Board of Appeals is the Conservation Commission. They step into the shoes of every local permit granting authority.
But the Concom is still responsible for the notice of intent under.
Concom still acts under the Wetlands Protection Act. The Board of Health still acts under Title V. Building inspector still acts under the state building code. If it's a state permit that's being issued, but it's a local permitting process, then it's still the local entity that always has jurisdiction. It's only when it's a local, rule or regulation that's impacted. So once the hearing's closed, the board has 40 days to issue its written decision and have that filed with the town clerk. 20 days after the board's decision has been issued, the abutters have a right to appeal. Those appeals go to either Superior Court or Land Court, and the applicant has a right of appeal. That appeal goes to the Housing Appeals Committee, which can get confusing. All right, getting to the board's hearing process, the board has every right to request that the applicant participate in a site visit so that they can get a better understanding, as to the property that's involved, what the constraints are. And that is a public hearing in which the board cannot take any actual testimony other than direction. So you get out there on the site and the board can say, all right, so where is the buildings going to go? Have you staked out the roadway? Where is that going to be? Show me where the wetlands are. But there can't be any actual testimony provided at that site walk.
How are you defining testimony in that? What
Testimony would be anything that pertains to the application that is not directional in terms of being on the site.
So opinions.
Correct. Right. Negotiations, nothing of that sort is appropriate for a site visit. Retaining peer review consultants. The board absolutely has the right to request that the applicant pay for peer review consultants. That can include civil engineering, traffic, wetlands, wildlife, septic issues, anything in which the board is going to be requested to actually exercise some jurisdiction and therefore needs to take a look at. Stormwater is another one. So you've got a local stormwater bylaw. The board is going to be asked to administer that as part of its decision. You've got the right to retain a peer review consultant at the expense of the applicant to review stormwater. Go ahead.
The board selection of the consultant.
So the board selects the consultant. There is a appeal process if the applicant disagrees with who the board selects. That appeals process is set out in statute. It's the same for any other peer review selection. The only real reasons to object to a peer review consultant are either conflict of interest or a lack of expertise in the subject matter.
And then when the applicant provides funds for this, that gets put into an escrow account?
Correct. Yep. And anything remaining at the end of the process is returned to the applicants.
So the process for that is if we feel that we get the application, we feel we need the consultant review, we have to identify the consultant, ask them for a proposal, that has to come back, the monies have to be delivered, and then the process.
Right, so frequently what you would do is actually send out requests for proposals to multiple consultants, review them. You could share them with the applicant, see if they've got any concerns, because the applicant may say, all right, well, I've actually worked with this consultant before, they've actually looked at this property before, I've run into them. So you sort of want to clear those out before you're into a contract.
That all happens within 180 days.
That all happen, you want it to be well in advance
Well,
of the 180 days. So usually, I like to have the process at least begun at the first hearing. It's usually a good idea to have the board appoint a staff member to just oversee the peer review consultant selection process. Give them the authority to actually choose the peer review consultant. That way you're not stuck waiting for the next meeting every time, so that the board can vote over and over again with regard to peer reviews. Because if that happens, now all of a sudden you don't get the peer review started until the third month. You've only got 3 months left of hearings to actually go through your peer review process. So you want to get that commenced as quickly as possible. So peer review fee can only be, and these are sort of unique to Chapter 40B. Review fee can only be imposed if the work of the consultant consists of review of studies prepared on behalf of the applicant and not independent studies on behalf of the board. So that's an important consideration. So if you think that there's an issue with the traffic, the board doesn't just go out and hire a traffic consultant to perform a traffic report. They hire a traffic consultant to review a report that's been submitted by the applicant. So if traffic is a concern and the applicant hasn't submitted a traffic report, the first thing you're going to need to do is say, we want to see a traffic report. And then we're going to hire a peer review consultant to review that. And then if they say no, you're in the point where you say, well, that's information that is of great importance to this board, and we can't make a decision without it, so we will deny for a lack of information if you don't provide us with that study. The work that's being peer reviewed has to be in connection with the applicant's specific project, so you can't have them peer reviewing things that are of public interest that aren't actually part of work being done on their project. Then all written results and reports have to be made part of the record before the board, which is never an issue that I've seen. Negotiation in work sessions can be very helpful, particularly if they're kept to the level of the experts. So you've got peer review process going on. There are very technical questions that can be raised. I'll give you an example. I'm representing the Board of Appeals down in Shrewsbury right now, and they've got some very significant sewer concerns. And there's a consultant for the applicants that is trying to come up with ways that they show that they can put their sewage flow into the municipal sewer system and not cause it to have any problems. And you've got a peer review consultant from the board who is saying, no, we've got issues at this station, this station, this station. They've been meeting together in workshop sessions, trying to narrow down the focus of what the issues and concerns are. That is something that can be very helpful, because holding multiple full-length board hearings on sewer issues is not usually very productive. So this helps actually get the process finished within the 180-day period, while still addressing all of the very legitimate technical concerns that can be raised.
And those work sessions should be,
They can be noticed. Public can
Noticed.
certainly attend them.
yep,
A lot of times they don't bother to, because who wants to listen to them talk about sewer? Balancing regional housing needs with local concerns. So this gets down to the issue of the decision of the board at the end of the process. What exactly can the board rely upon with regard to its decision, whether it's imposing conditions or whether it's determining that it's going to deny the project? So you need to take a look at the listed issues here: health, safety, environmental, design, open space, and other local concerns. You have to tie every single condition or the denial itself into one of those legitimate local concerns. And then ultimately, if there's an appeal, the Housing Appeals Committee is going to take a look at whether there are actual local, regional housing needs that outweigh those concerns. And oftentimes they do, yes.
What would be an example of other local concerns?
You know, there really isn't a good definition, but I will give you one. Planning is one where occasionally and it's in very, very specific circumstances that denials have been upheld based upon municipal planning concerns. There was one down in Barnstable several years ago where the town actually had done a zoning district. It was very well thought out, and it was in a commercial area by the water, so it was sort of a waterfront commercial district. They had a very specific vision for that particular area. They had done affordable housing development elsewhere. They had plans that were in place to create affordable housing elsewhere in town. So the Housing Appeals Committee took a look at those planning issues and said, in this particular instance, we are going to uphold the denial by the board because a 40B development in that zoning district is not appropriate. However, since that case came out, there have been, dozens of boards that have tried to rely upon it, and the success rate is very low. So we're holding deliberation sessions. So once the board closes its hearing, as I noted earlier, it has 40 days to actually render its decision and submit it to the town clerk. So generally what happens is the board closes, schedules another hearing night within that 40-day period. You get a draft decision and the board goes over it. You can get some feedback from the applicant. It really depends upon your tolerance for that sort of thing. Some applicants want to treat it like it's an open meeting, but it's not because the hearing's closed. So they can't actually give you any new substantive information. The way I generally deal with it is to say the board is going to present draft conditions, a draft decision. The applicant is allowed to inform the board whether or not it finds those conditions will render the project uneconomic. So basically, we can't live with that decision, or we can live with that condition. And that's okay to get that kind of input. What you can't get into is a trading session. Well, how about if we make this revision and we do that? Because those are substantive issues, and that has to be done when there's an open public hearing. Drafting and issuing the comprehensive permit decision, I think we covered this already. There's three alternatives: denial, approval as submitted, which never happens, and approval with conditions. So approval with conditions and/or requirements have to be considered in the aggregate. I know that there's a number of attorneys out there who attempt to take the position that you have to justify every single waiver that's requested, and that every single condition you can look at individually and determine whether it renders the project uneconomic, but that is not what the case law says at all. You take a look at the totality of the decision, and if all of the conditions as imposed render the project uneconomic, then it's going to get overturned by the Housing Appeals Committee unless you can show one of those local concerns that outweigh that. Conditions and/or requirements must be consistent with local needs, which we discussed. Feel the need to discuss local preference. So the board actually is allowed, as part of its decision, to require a certain number of the affordable units be reserved for local preference. Not allowed to put in a requirement of more than 70% of the affordable units as a local preference, but even that is not really what you're going to get. Because what's going to happen is if the board imposes a local preference condition, that has to be upheld by the state. And the state is going to actually require the town to submit evidence of the need for that local preference. Because there are serious fair housing concerns that weigh into that. So if the town isn't able to show that there isn't a sufficient local need for that local preference, they're going to have to be able to show that it's not going to result in discriminatory practices and fair housing concerns. So you have the right to set aside the 70%, but that could be overturned later. Zoning Board of Appeals, Williamsbury versus the Housing Appeals Committee, a case that's near and dear to my heart because that was one of my cases back when I was with my old firm. And this case actually is important. It came out in 2010, and what it really does is informs boards exactly what the level of their jurisdiction is. on a comprehensive permit project. There are certain aspects of a project that the board simply doesn't have any authority to take a look at. And in particular, those aspects have to do with issues within the exclusive control of the subsidizing agency. So the level of affordability, regulatory agreements, deed riders, those sort of things that are part of the final approval process with the subsidizing agency. The board certainly can put in conditions that say that we'll have the right to review them, should be given a copy of them. Cost certification is another one of those issues. So the board's decision can address them, but they can't try to control them. You can't put a condition in a decision that states that the board will have approval power over the regulatory agreements. If you do that, that's just going to get tossed right out. Now, one of the important issues from the Amesbury case is that the Board of Appeals doesn't have the authority to impose conditions unless it's a condition that could be imposed by one of the boards into whose shoes it's stepping. So I use as an example, you can't require all of the workers on the project to wear red shirts every day. There's no board in town that would have the authority to impose that requirement if this were a conventional subdivision or if they were in front of the Conservation Commission under the local wetlands bylaw or anything like that. So if there is no local rule or regulation that addresses that particular issue, the board can't simply decide, well, we're going to do it anyhow. One of the provisions of the statute, Chapter 40B, Section 20, is that you can't treat a subsidized housing application differently than you treat a normal housing. So if you've got a rule for a subdivision that says that the length of dead end is 500 feet, the Board of Appeals can't say, I think we really don't like that requirement, so we're going to say that you can't have a length of dead end longer than 350 feet. We just feel that's better. If the board tries to impose a condition like that, it's going to be overturned. Managing the comprehensive permit. This is something that most boards don't really consider when they're issuing a comprehensive permit, and most attorneys don't consider when they're actually assisting a board in issuing a comprehensive permit. But as a former member of the Board of Appeals in my town, in which we had comprehensive permits that were issued before I was on the board, come back to the board with questions and concerns, and board members would take a look at it and say, I don't really know why we imposed that condition. So how do we interpret it? It becomes a bit of a problem. It's certainly a problem for the applicant, but it becomes a problem for the board. So the board needs to be aware when it's issuing its decision, it's not the end. Almost every single one of these projects is going to wind up back in front of a board for one reason or another. Very, very frequently, they come back for modifications. So under the regulations, 760 CMR 56.0511, an applicant that has an approved comprehensive permit can come back to the board and say, the permit that you approved isn't economically viable anymore. I need to make some changes. Those changes can be pretty significant at sometimes. So the threshold is the board will take a look at that request and it will make a determination as to whether it's substantial or whether it's insubstantial. If it's insubstantial, which is I wanted to move that house 6 inches because some issue that we ran into during construction, the board can simply find it insubstantial, do nothing, no public hearing, and it's automatically approved. If the board finds that it is substantial, then it actually has to hold a duly noticed public hearing. Right? So that means all the abutters get their notification, have a public hearing, take testimony. You actually can do peer review of new plans. I've had hearings on modification requests last as long as an initial hearing would last. 4 months, 5 months, 6 months. So, yes.
If it's insubstantial, when does that determine, the application is made back to the board?
And the board has 15 days to make its determination. So it's
And the board has to meet the public in order to discuss that.
Correct.
And how long does that the applicant have to get those to you? And the decision, I assume, is good for only a certain period of
So
time?
a decision is good for 3 years, and I think that really concludes the PowerPoint presentation, so we can go to straight questions at this point. Decision is good for 3 years. It lapses after 3 years, but the applicant has the right to come back and request extensions.
Okay.
Those extensions cannot be unreasonably denied. I have never seen a requested extension that's been denied be upheld on appeal, as long as the extension is requested within the time period that the permit is actually still valid. The day after it expires, you can't resurrect it through a request for an extension.
And an extension can be up to how many years?
3 years.
Same amount? Okay.
And then at the end of that 3 years, they request another one.
They
I
do
have
another one.
seen
Okay.
projects that have been 10 years, 12 years, just extension after extension. I had one very recently in which a board denied a request for an extension. An appeal was taken to the Housing Appeals Committee, and we were able to, as part of that process, I was representing the board. We were able, as part of that process, to get the applicant to agree that if they did not commence construction within 12 months of the date of an agreement we made, that any new request for an extension would automatically be considered a substantial change that would require a new public hearing. But generally, they're deemed to be an insubstantial change and automatically approved.
So if they come back with a proposal for some changes to their permit,
Changes can be really, really significant changes too.
Right.
So I had a project where I represented an applicant in Lunenburg where the original application was for 120 ownership units. What was ultimately approved was 64 ownership units. Market crashed and the applicant said 64, I thought it was going to work, but I'll go broke if I develop this. So he wanted to come back in and do 80 ownership units during the course of the proceeding, which lasted more than 6 months actually. The board was very reluctant to allow the 80 units, but they said, you know what? We think 120 rental units on this site would actually be more beneficial. And they approved 120 rental units on a project that was originally approved as 64 ownership units, all as part of a modification. And I'm not sure, to the extent that people are aware, there really is a significant benefit to the town to have rental units over ownership units, because the town gets to count 100% of the rental units towards its subsidized housing total. It only gets to count the actual affordable units on an ownership project. Yes, ma'am.
A couple of questions. Number one, how exactly does this process work? The town, the zoning board of appeals is represented by council at different stages.
Yes.
The applicant is represented by council.
I have not seen counsel for the applicant on the project you're talking about,
I believe I saw something that they,
but we're gonna stay away from specifics on this project, so we'll talk generally.
well, no, I'm, generally speaking, lawyers get involved,
Yep.
right?
Which is good for me.
So when you have this open hearing, if you are, have issues with the project, do you, if you're an individual, do you just go to an open hearing and say, I object for these reasons? Or do you get to see the reports on traffic and safety and fire hydrants and all of that? And
Yes to both of those questions. So the way the process will work, generally will work, the board will run its hearing as it sees fit. But generally what you'll have is at the initial public hearing, the applicant's going to give a presentation. That presentation is going to be a very general overview of the project. It will have its civil engineer, and it's in fact similar to what was done in front of the Board of Selectmen on the most recent application for an eligibility letter. You'll have your civil engineer do a presentation. You may have an architect there to do a presentation. Sometimes you'll have a traffic consultant there at the initial public hearing. We'll go over what the traffic issues will be. Once the applicant has completed its presentation, the board may ask some questions itself, and then it will open it up to the public, and the public will get up and they'll ask whatever questions that they feel they need to ask.
But the answers are going to be coming from the applicant?
Depends on the
Town?
nature of the question. If the question is something that really can only be answered by the applicant, if it's a very specific, I know, is the applicant willing to make this change? Can the applicant explain, how it is going to handle stormwater on the site? And that's not going to be addressed by the board, certainly not going to be addressed by council as to how you're going to deal with stormwater. So some of the questions will be answered by the applicant or the applicant's consultants. Once we get further into the process and peer review engineers are retained, some questions will be answered by the board's peer review engineers.
So is it normal for those who are concerned about a project to hire their own civil engineers?
It happens. It's more common for residents who are concerned about a project to hire their own attorney. I see that frequently. I don't often see the hiring of civil engineers, although when there are specific issues of concern, it does happen. And it generally tends to be direct abutters who think, all right, this is going to cause me stormwater concerns. I want my own person to take a look at these plans and tell me whether or not, because I don't trust anyone else.
And just, I don't want to offend anybody, but in your experience, do these zoning boards tend to be neutral hearers of fact? Or do they have some vested interest in satisfying the state requirement for affordable housing within their community so that they can do it and get done with it and it's not going to be an issue down the road?
The response I will give to that is based on my experience, having been a board member in my town. The board members very much don't want to upset their fellow residents. They tend not to like the idea of local rules and regulations that they usually are administering being overridden by an applicant. But then they also take into account that if they issue a decision that is not legally tenable, it's going to get overturned and their ability to impose conditions and to reduce impacts is going to be lost. So there's sort of a balancing going on there. Yes?
Can you say more about subsidizing agency? Who might that be and what roles is it?
Well, so there are multiple different entities that can act as a subsidizing agency. There is Mass Housing. There is the Department of Housing and Community Development. If it is a LIP, which is a local initiative process, that actually requires the involvement of the Board of Selectmen and the support of the Board of Selectmen for a project, to do a LIP project. Mass Housing Partnership is an entity that issues eligibility letters, and on occasion Mass Development.
Well, we build before it be 25% of it has to be affordable housing.
Correct.
Do we get credit for all of the houses that are in that?
No. No, so that's the point that's the point I was just making is, for a rental project, you get to count 100% of the units in the project. For an ownership project, you only get to count 25%, and that's a policy that the state has made many, many years ago now, in order to encourage and incentivize the creation of rental housing, because they found that towns were much more objectionable to rental housing than they were to ownership developments.
So you said the CBA can request more affordable?
No, the CBA may not. There's actually a specific provision in the regulations that says the board cannot impose a condition that requires a greater amount of affordability.
Thank you.
Paul, go ahead. I might need some clarification in your timeline of when the decision is drafted, and then there's a period of time, you say, for negotiations between the applicant and the board. Does that imply that there's no negotiations
No.
for the first 6 months?
No, negotiations should be occurring, and they should be occurring during open public
During the
hearings.
open public, where you're
So-
a free flow of discussion back and forth between the applicant and the.
Correct. But during the deliberation process,
After it's closed.
after the hearing has been closed, and it depends on how the board wants to do it. Sometimes boards actually have their decision completely prepared and ready to issue before they close the hearing. Just to make sure that everything is done in front of an open hearing, to make sure that there aren't any last minute issues that crop up that they can't deal with because the hearing has been closed. What I'm talking about in terms of back and forth with the applicant during deliberation is more when you hand out a copy of the draft decision and there are conditions that the applicant says to the board while they're deliberating, we can't live with this condition. Well, you can't really get any more than that. You can't say why will you not accept this condition. What condition would you accept? Now you're getting into testimony and you can't do that with a closed hearing.
Right, okay.
But they can just simply indicate, if you impose that condition, we are going to take an appeal.
If the ZBA is acting as the board for all the other boards.
Yep.
What is the proper procedure for interaction with those boards, should the ZBA want input or have questions
They-
from other boards?
Other boards can submit written information and testimony to the board. They can also appear at the zoning board of appeals hearings, testify in front of the board. Board should not be soliciting information from anybody outside of the public hearing process in terms of discussing the project with other board members, with other boards in town, even with individuals, which can be very difficult to understand. But it's not a good idea.
You mentioned earlier that there's not a subsidizing agency. When there is a subsidizing agency, the board can't issue any extraneous conditions.
There's always, there has to be a subsidizing agency, or you're not allowed to do a comprehensive permit project.
So in the case of an application that was in under Department of Housing, they're the subsidizing agency.
Correct.
So can the board negotiate any additional constraints, restrictive covenants on the deeds or anything like that?
Well, that's not an issue for the subsidizing agency. Issues for the subsidizing agency have to do with their regulatory processes, in terms of the affordability, in terms of the cost certification of the projects. All of that is within the exclusive jurisdiction of the subsidizing agency. Imposing a condition requiring a conservation restriction.
How about
or
something like
restricted-
owner-occupied housing?
That is an appropriate condition,
It is appropriate?
yes.
Okay.
That's okay.
It's my understanding that once the site review is done, then the planning board has to issue a letter to Mass Housing. What is the nature of this letter, and is it possible for people who have concerns that aren't on the planning board to incorporate their concerns in this letter, and if so, how would they do that?
All right, so speaking generally, with the site eligibility process, the way it works is the applicant submits their application to the subsidizing agency. The subsidizing agency then gives the municipality, it's usually 30 days, there can be things that crop up that the time is extended. But you get 30 days to issue written comments. Anybody can certainly submit comments to the town, and then the town can take and incorporate those comments into its letter, or simply include them as attachments to its letter. Comments can also be submitted directly to the subsidizing agency. But I just want to clarify, it's not necessarily the planning board that is the entity that submits that letter. They certainly should be looking at those issues because planning is what they do, but the letter comes from the town as an entity, not from a specific board.
What's the timeline for the pro forma review?
It's a good question. I probably should have covered that as part of my presentation. So that's the one peer review aspect that actually is dealt with separately in the regulations. You're not allowed to conduct a peer review of a pro forma until the end of the process, and if the board wants to conduct that, they're required to issue a draft decision that contains all of the relevant conditions. so that the applicant can know what exactly it is that is the project that they're being asked to have reviewed. And then at that point, the applicant has two choices. They can say, this draft decision is fine, we're willing to live with this, or they can say, no, this draft decision is going to render our project uneconomic. If they choose the latter option, that's the point in which the board can then request to have a peer review consultant review that portfolio. I'm going to tell you, it's not generally a fruitful process, because you're going to have a draft decision, the applicant's going to tell you that it renders the project uneconomic, he's going to have his pro forma consultants swear on a stack of Bibles that it renders the project uneconomic. You can bring in a pro forma consultant who may either agree with them or is going to differ potentially substantially. And then where is the board left?
Isn't the entity of the eligibility letter the one that performs the
No,
formal review?
They will do an initial review of the pro forma as part of the submittal of the eligibility letter. But the board is not bound by that review, although one interesting quirk of that process is the applicant is bound by the profit percentage that is approved by the subsidizing agency. So generally, under Chapter 40B, the threshold for uneconomic for an ownership project is a profit level of 15% of total development costs. Okay? But quite frequently, an applicant will come in with a pro forma that shows a profit of less than 15%. So say Mass Housing has a pro forma submitted as part of their application, they review it, they approve the project, they issue an eligibility letter, and that pro forma shows that the profit will be 13%. Well, that is now the uneconomic threshold, not 15%, because the applicant's already told you they're willing to live with the 13% profit. And that's a relatively new provision of the regulations.
Paul, what is that pro forma? Is that come in with the application initially, or is it?
It's not a required component of the application, but it's frequently included. But it is a required component of the Mass Housing application. So we already have whatever was submitted to Mass Housing as a pro forma.
Mass Housing has the application now.
So let's move back and get more general again.
So, what's the timeline that the entity has once they receive the application before the application then is presented to the board, the ZBA?
In terms of when the subsidizing agency gets the application, and then when the application is filed with the board?
So, is the schedule written right now?
No, there's no schedule.
If it was submitted.
It's simply a matter of how long it takes for the subsidizing agency to review an application. It used to take them quite a while. I have had instances where it's taken over 6 months to obtain an eligibility letter from the subsidizing agency. My understanding is that Mass Housing in particular is now trying to commit to get eligibility letters out within 3 months, but again, circumstances come up sometimes that takes longer. Once they've got their eligibility letter, the applicant can file their comprehensive permit application basically whenever they want to. Sometimes they don't do it right away. Sometimes they've sort of sat back, they haven't completed some of the other things that they need as part of their application, so it takes them a couple months before they actually file. I've been involved in situations where there have been safe harbor issues, where I've told the client, just wait until this particular period runs out, and then you file. As long as they file while the eligibility letter is still valid, and those have a 3-year shelf life, I believe, 2 or 3 years.
And when the application is submitted, is there any review that the application is complete at that time in order to start the schedule?
No. There is not, and there is actually a specific provision in the regulations that states that failure to include one or more of the submittal requirements contained in the regulations does not mean that the project can be denied for an incomplete application, or that the time periods. The submittal of the application is actually a very important date in the process for 40B, because that locks in a number of things. It locks in the safe harbor for the 10%. So if a town is at 8.5% and an applicant files a comprehensive permit application on that day, and then the next day the town approves a project that puts it over 10%, it's only at 8.5% for that project. Forevermore, the date they filed their application is the applicable date. Another issue is your local rules and regulations that apply to that project are only the rules and regulations that were in effect on the date that they applied. So if there is a zoning bylaw change, if there are changes to the planning board rules and regulations, if there's a local wetlands bylaw that becomes much more restrictive, they don't even have to request a waiver of it. It's not applicable by regulation.
Would
What
it be
else?
fair to, if you wanted some other board or department participation in a review, to involve them in one of the work sessions that is a public
Certainly
meeting?
appropriate.
That's okay? Okay.
My feeling on workshop sessions is if a board member is going to participate, you shouldn't have more than one. And that includes board members from other boards,
Yeah.
just because you don't want to run into open meeting law issues.
Okay. Sounds-
Does the state at all have any sense or guidance for themselves about when the waivers are requested, to what extent, do they egregiously go against the existing codes of the town?
No. It's honestly, it's not particularly relevant. They're not going to look at the difference between what was requested and what the town requirements are. They're going to look at the impacts. The board, as well as the state, subsequently, if it goes to an appeal to HAC, they're going to look at the impacts of the specific project on the surrounding area and on the town. It's, if you have one town that has a 5-acre zoning requirement and another town that has a 20,000 square foot requirement, it's not going to make a difference as long as the project that's being applied for doesn't have different impacts. If the impact's the same, what the existing regulation is not really relevant.
Does the state have any precedent for very successful developments and also projects that just awry or failed after?
There are lots and lots of examples of successful developments. Most of the developments that I've ever had any involvement with that have moved forward have not had impacts that people had been concerned about at the beginning of the process. Now, a lot of times that's because boards of appeals and their consultants and other members of the town work really hard to actually mold that project into something that is less impactful. There are bad projects out there too, though. There are projects that don't get finished, that are half done, and then the developer goes belly up. So those are concerns that have to be taken into account as well.
So what happens in that case?
Well, it's an interesting question. I'll give you an example of one I'm aware of in Wakefield, where you had a very, very shady developer who I believe ultimately went to jail for multiple reasons. But he went in and built all of the market rate units in an ownership project, declared bankruptcy, and built it. Never built any of the affordable units. Towns in the state have gotten much wiser since those days. This was, I think, back in the late 1990s. So any decision that I've ever seen is going to have a condition that requires the units to be built in proportion, so that you're not going to get building permits for more than 3 market rate units without building an affordable unit.
And is there any situation where, over time, the affordability of the affordable units is lost?
It can happen, yes, and it's unfortunate. With regard to ownership, you see it's less of an impact because it tends to be one here, one there. But I'm dealing with one now in one of our towns where the town is trying to come up with the money to exercise a right of first refusal because one of the affordable homeowners is being foreclosed on. And the foreclosure, in this instance, would wipe out the affordability restriction. Now, this is an older project. The deed restrictions that they have now actually have provisions that survive foreclosure. So it's less likely if something like that would happen, but it can. With rental projects, it can happen 15, 20 years later. But the board has the right to require that the units remain affordability in perpetuity. So if there's a foreclosure, what may wind up happening is you've got a tenant in there who wasn't subject to the affordability requirement, but that unit would still have to be resold at an affordable unit rate. So ultimately, you should be able to get someone back in.
So Paul, we have a couple of provisions. One is that we require in our subdivision regs a performance guarantee.
Yep. Very typical to have similar.
And so we can have that still here.
Very typical
And
conditions.
what about, we also hire engineers to oversee the construction, to represent the interests of the town?
Yep. So are you talking about a clerk of the works, or is it someone that's just more of
Any
a
sub.
peer review engineer
It's a
checking
peer,
in?
it's a peer review.
Yeah. And one thing to keep in mind is, with regard to imposing conditions, if there is a local rule or requirement out there that actually already exists, you've got a very good chance that that condition is going to be upheld, as long as you're not somewhere else rendering the project uneconomic. Where you can run into trouble is where you try to start imposing conditions that aren't imposed elsewhere. As I said earlier, there is a requirement right in the statute that says you can't treat unsubsidized housing differently than you treat subsidized housing. So if you have a requirement in your subdivision rules and regulations that requires a peer review engineer to take a look at it during the process of construction, and the board says, hey, we don't think that's good enough, we're going to impose a requirement that there's a clerk of the works who's there all the time. The applicant's going to object to that almost certainly, and if they take an appeal, it's probably going to be stricken, even irrespective of whether or not it renders the project uneconomic, just simply because it's subjecting the applicant to any treatment.
How is the affordability determined on a long-term scale? And the reason I ask is, if people are owning these units and somebody puts an extra garage on it and then goes around to sell it, do they lose the value of that garage? If it's in, how does that function? If there's modifications made?
So once the affordable units are constructed and you've got tenants, they're actually going to be overseen by the state. There's going to be a monitoring agent of those affordable units. I'm not sure that they would be allowed to add on to the property. They certainly would have to go through the state agency and get that permission and try to get their, because they're going to have a deed rider that's attached to their deed, and that's going to contain all of the affordability requirements. It's going to limit what they can sell it for on a resale. The way the affordable price is determined is actually through a formula, and it has based upon applicant who's who makes 70%. I think it's actually 80, but they try to price it at 70%. Not spending more than 30% of their income on the housing. So that's how you qualify as an affordable buyer. And if you go to sell years later, that's what the next buyer, that's how they're going to determine. And it also throws in the condominium dues, impact it, interest rates impact with the affordable prices. So it can go up and down, and also the median income. As it goes up, the price can go up a little bit. So that's how the price is determined, and that's what the buyer is limited to in their resale. But one thing on a home ownership that's not applicable on a rental is that if you qualify on the day you buy, you own it for 30 years, and you go from being someone who is at less than 70% area median income to 30 years later you are a multimillionaire. You're still allowed to be in that affordable unit, and it still counts as an affordable unit. Once you've purchased it, it's yours. But once you go to sell it, again, you're subject to only that affordable sales price as determined by the monitoring agency.
Is that connected at all to square footage or the size of the house, or is it?
No, it's just simply based on the formula. There is a component of the formula that is based upon the number of occupants, family size. The price, it can go up a little bit if the number of bedrooms can raise the price a little bit.
So Paul, in terms of the HOA, and this is gonna be a condominium, oh,
Yep.
but.
Well, presume that there isn't a project that would be a condominium
Let's assume
development.
that, would a town have the ability to review that HOA agreement?
That would be a typical condition. Every condition, every decision under 40B I've ever drafted, including decisions where I'm drafting it for the applicant, you always put that in. It's not at all unreasonable.
Would you go over the safe harbor 1.5% provision again?
Okay, so
Confused.
that is not going to be something that's going to be applicable here in Newbury. What it would be is if you've got a town that is either really dense, densely populated, one of the sort of inner ring cities and suburbs, or if you've got a town that has just an unusually large amount of land that is state-owned, so conservation, state or federal conservation land, and you've got affordable housing developments that take up a fair amount of acreage, then theoretically that 1.5% would apply. But again, Stoneham just tried it, Newton just tried it, and they were both unsuccessful. I know there's a couple other towns that are working. Hingham, I think, just tried as well. I'm aware of one case where a town was successful in making the claim, and that was 10 years ago at least.
Has that been calculated, Martha?
I haven't, I don't know if anybody else.
It's a very complicated calculation. There aren't any guidelines. I know DHCD is working on trying to come up with those sort of guidelines, but the odds of Newbury falling within there are very slim.
And Paul, it changes.
Well, every time there's a project that's approved, it changes, because then, once this project is approved, the amount of area that you have subject to affordable housing goes up. But it tends to be the case that you're going to get to the 10% a lot more easily and quickly than you're going to get to the 1.5%. It's a rare set of circumstances that the 1.5% is applicable.
If you've got the comprehensive permit application going and also, say, conservation and board of health going at the same, presumably at the same time.
Yep.
Have you seen a case where the ZBA is conditioned, based on approval by the Concom or Board
Absolutely.
of Health, and then one of those denies it
Yep.
for some reason?
I'm involved in one right now down in Sherborne where I represent the applicant, and it's a very, very controversial project down there. And the Board of Health denied the Title V permit, and the Conservation Commission denied the order of conditions. So that's, order of conditions is under appeal for a superseding order with DEP, and the Board of Health decision is under appeal at the Land Court. Both of those occurred before the Board of Appeals completed their process. They simply issued a decision that said, you need to have a valid Title V approval that's unappealed. You need to have a valid order of conditions or superseding order of conditions that is unappealed. The Board of Appeals cannot and should not put itself into a position where it's trying to act under state regulations over which it has no jurisdiction. Just, if there is another body that is responsible for making that determination, let them do it. Anyone else?